Hello everybody. Thought I would do a video. We've been spending the day with our kids, had a wonderful day with them, so it was nice to get away. And I want to thank GS very much for sending me the latest documents. We have an update on the Pinkava case and some interesting things, and of course I will be giving my personal opinion as I read some of this, and which I am entitled to do. Now I want to also incorporate GS's email into this, and thank you, sweetie, so much. I appreciate your help in getting these documents to us. Appreciate it. Now, before I get into this, I just want to mention that the U.S. Supreme Court has just ruled that all churches can open up 100% in the United States here. So when I heard that, it made me wonder, what is Watchtower going to do now? Because we already know that Jehovah's Witnesses love their Zoom meetings. They really don't want to go back to the Kingdom Halls. So, it's going to be interesting to see, what takes place the next few months as churches can now open. And, yeah, interesting. On April 16, 2021, the state attorney filed its response to the defendant's motions in limine number 3 through 6. And, in past videos I've covered those limines that the defendant had filed, and he's basically claiming clergy penitent privilege, and Watchtower lawyers gave him bad advice, and that whole thing. He's using every excuse he can. But, in reading through this, in my personal opinion, these elders are going to fry. And I don't mean fry literally. It's a saying here in the United States, a hyperbole, if you may. I'm going to mention her email, read her email first, because she has a summary of all of it, and then I noticed a few things in these documents that I wanted to cover. Number one, the conversations between the offender, Hernandez Pedraza, and the 3-elder judicial committee that took place on July 27, 2006 be ruled inadmissible. This is what is in the limine that the defendant had filed. They're trying to get this evidence inadmissible. Number two, the conversation and any information Pinkava received during the confessional meeting with Hernandez Pedraza be exempt and inadmissible. Can't have your cake and eat it too. The conversation between Mrs. Hernandez Pedraza, the wife of the pervo, and the mother of the victim be deemed part of the confessional process and be ruled inadmissible. So even their discussion with the wife, they want to be inadmissible as part of the clergy penitent privilege. Any information Pinkava received during the confessional be exempt from mandated reporting. Among other things, in the state attorney's response, at the end of the first paragraph on page 14, the state's attorney states that allowing a church to define what are confessions or admissions would allow it to hide all such conversations under an umbrella it itself creates. So, what Watchtower is trying to do is say what should be exempt or inadmissible and exempt, and the clergy penitent privilege. Well, that's like the Catholic Church saying, oh, well, we don't have to share all of this information because it's in the confessional. Well, we're going to get into the statutes because I was highlighting so much I ran out of highlighter on the way home. In the next paragraph, the response states, in relevant part, that essentially with respect to conversations had with Ms. Hernandez had nothing to admit, nothing to confess to, and did not seek spiritual counseling from the defendant, Pinkava. Rather, defendant Pinkava admits it was he who sought out to speak with Ms. Hernandez after learning of the possible CSA of her child from Mr. Hernandez. So they are hoping the court will rule in the state attorney's favor and make these conversations and documents admissible in this case. Arguments on the motions in limine is still set for April 29th. So that is this coming Thursday. So hopefully the state attorney, but I've got the documents here. Thank you so much, sweetie. 15 pages. And I will put these on our website. And like I said, scroll down to the bottom to get the latest documents. They do a background of what happened. Now, let me remind everybody that, well, I'll just read this right here. On July 27, 2006, defendant, in his capacity as an elder of the Crystal Lake Spanish congregation, was made aware of a possible CSA occurrence. Defendant, a mandated reporter as defined in 325 ILCS 5/4 as a member of the clergy, did not report this matter to the agency or authorities. Rather, the defendant engaged in a number of discussions with others regarding what he had been told. For failing to report to the proper agency and authorities, defendant was charged with a violation of failure to report, a Class A misdemeanor. And like I've mentioned before, they might be trying to up that to a Class 4 felony just because it went on for 12 years and he knew about it and did nothing. Alright, now I'm gonna, they go through some details. On page 3 here, argument. The issues before the court are twofold. Whether to consider the conversations mentioned in motion in limine number 3 and motion in limine number 5 are privileged communications pursuant to 735 section 8-803 and therefore inadmissible without waiver by both parties. And number 2, whether any information received during these conversations is exempt from mandated reporting pursuant, as mentioned earlier, which incorporates the clergy patent of privilege. There are a number of locations that clergy are referenced in the Abused and Neglected Child Reporting Act, specifically the 325 ILCS 5/4 reads in a pertinent part. A. The following persons are required to immediately report to the department when they have reasonable cause to believe that a child known to them in their professional or official capacities may be an abused child or a neglected child. And then it has number 9, any member of the clergy. So if you're going to claim clergy patent privilege, then that makes you a mandatory reporter. And it even mentions in here school, facility or agency or church, synagogue, temple, mosque, or other religious institution. Under that in G, the privileged quality of communication between any professional person required to report and his patient or client shall not apply to situations involving abused or neglected children and shall not constitute grounds for failure to report as required by this act or constitute grounds for failure to share information or documents with the department during the course of a child abuse or neglect investigation. So what this is saying is you don't get the clergy patent privilege. You have to report this, and as long as a child is in danger, you have to report it. And this all boils down to they're claiming clergy patent privilege and, oh, we didn't have to report it. Yes, you do. Like I just said, in that statute, they have mandatory reporters. If you are a minister, clergy, priest, a teacher, which Pinkava was both. He was a certified teacher in an elementary school and claiming clergy, an elder in this congregation, then he is a mandatory reporter. I go on, page 4. I. By adding members of the clergy to the list of mandated reporters, the legislature intended that clergy report instances of CSA of which they are made aware. The Act has been amended numerous times, but relevant to this matter is the amendment that went into effect on August 16th, 2002, 4 years before this incident. So according to this, he is on the list as mandatory reporters. You cannot claim clergy patent privilege. And they get into more of that. And I love this at the bottom of page 4. Statutory interpretation, amendments to statutes, and case law aid the court in its determination of the issues raised by the defendant. It is well established that a statute must be interpreted by the courts with its purpose in mind as a whole, giving no weight to one section over another. Furthermore, a statute cannot be interpreted to allow for absurdities. Like I said, Watchtower and their elders and their lawyers, you're busted. Additionally, we interpret statutes as a whole, rejecting an interpretation that exalts one provision of a statutory scheme over another. And they have a list of cases here. So, but this is basically saying Watchtower cannot interpret the law themselves and say this doesn't apply to us. Oh, well, that might apply, but this doesn't apply. No, Watchtower cannot interpret these statutes themselves. I'm going to try to, get through this as much. Like I said, it was 15 pages. Okay, here at the bottom of page 7. The defendant in its motion states that defendant acquired information in his capacity as a member of the clergy of the Kingdom Hall Spanish congregation, Crystal Lake, of allegations of CSA from Mr. Hernandez Pedreza. Defendant is therefore, by definition, a mandated reporter. Then they name a case here, People versus Burnage, which the defendant relies so heavily on in its support of clergy patent privilege and asked this court to do the same, was decided in 1996, prior to the 2002 amendment to the Act. You see what they're saying? They're trying to use a clergy patent privilege that they didn't have to report this and give information to the authorities. But that was back in 1996 when they weren't mandatory reporters. They're mentioning this, case. As of 2002, they are mandatory reporters. Well, this happened in 2006. So they cannot use the clergy patent privilege. I love it. I love it. I love it when these laws just, condemn Watchtower. The Burnage court ruled that the clergy privilege was applicable only because at the time clergy was not mandated reporters. See what that's saying? So if he's going to claim that Watchtower told him that he wasn't, he wasn't supposed to be a mandatory reporter, obviously they were not up on Illinois laws, because Illinois changed that in 2002. This happened in 2006. Mentions that statute again. Section 4 further provides that the privileged quality of communication between any professional person required to report and his patient or client shall not apply to situations involving abused or neglected children. So the minute this child, you find out this child is in a situation to where they are being abused, that clergy patent privilege does not apply. I mean, I'm not a lawyer, and even I know this. Based on the clear language, because they go into a whole bunch of legalese, based on this clear language, the state would argue, had the matter come before the Burnage court after August 16, 2002, after members of the clergy were added to the list of mandated reporters, the court would not have held the clergy privilege to be applicable. So, Watchtower and Binkava is trying to use an old statute that does not apply because this incident happened after the 2002 amendment. The court should look no further than the Act's title for the clear purpose to protect children from abuse and neglect by requiring reporting by certain members of society. The statute refers to these individuals as mandated reporters. See, and that's what this all boils down to protect the children. And what is Watchtower doing? Trying to protect their own asses. Oh, I get so angry. This court should hold that only confessions or admissions made for spiritual counseling be privileged communications. They can give spiritual counseling, but they still have to report it. See, this is the difference. Yes, you have a clergy penitent privilege to give shepherding or spiritual counseling at these confessionals, these judicial hearings. But that's as far as it goes. You still have to report it. But the defendant asked this court to deem inadmissible any and all portions of the conversations between defendant and Mr. Hernandez Pedreza, and between the defendant and the wife, Ms. Hernandez, pursuant to the clergy penitent privilege defined in the Code of Civil Procedure. So, you know, they're wanting these, this is what this court hearing is going to be on April 29th. They're wanting to decide if they have to turn over all of this evidence. And Watchtower and Pincava are trying to get this inadmissible to court as part of the penitent privilege. And like I mentioned before, Ms. Hernandez was not confessing to anything. So, you know, they cannot add her discussion and information, evidence. They cannot add that into part of, this is inadmissible because this is part of the confessional and judicial process. No, it wasn't. The elder went to her. Pincava went to her. Bottom of page 9, just want to mention this. They are, they have a case here in diocese, so I would assume this was another religion. And it says, they're just talking about this other case, and it says, this court does not believe that all communications made to clergymen are necessarily protected from disclosure under the Illinois statute, and we do not so hold. And then down here it says, admissions or confessions made to a clergy member in his capacity as a spiritual advisor in the course of the discipline enjoined by the rules or practices of the religious body or of the religion which the clergy member professes. See, protecting not only such admissions or confessions, but also any information obtained by a clergy member in his professional character. And this is what that diocese was arguing. And down here, they're like, no. In our view, the clergy member privilege extends only to information that an individual conveys in the course of making an admission or confession to a clergy member in his capacity as a spiritual counselor. The court ultimately required the diocese to turn over the documents sought by the state. So see, they didn't get their way either. And then he goes back to mentioning the People versus Burnage in another case. Two cases decided prior to 2002 and prior to when clergy were added to the list mandated reporters. Both these cases speak to the scope of the clergy penitent privilege. But see, like I said, you know, they're trying to use a case that was prior to 2002 when that amendment to the statute was made. I'm going to skip over here to page 11. We see no reason why the clergy privilege should be extended to exclude testimony offered by others who are not subject to the privilege. The defendant's attempt to place the statutory privilege on the same plane as the exclusionary rule fashioned for violations of the Fourth Amendment is clearly erroneous. Busted. I know this is long. I'm trying to hurry. Yeah, Similarly, without a determination that the conversation or information shared was an admission or confession from Ms. Hernandez made to the defendant for spiritual counseling, this court cannot rule this conversation to be privileged pursuant to Section 8-803. Defendant is attempting to place the statutory privilege on the same plane as the exclusionary rule. See, and that's what GS said at the beginning. You know, the wife was not confessing to anything. She was not admitting to anything. So you cannot include that in the confessional. Defendant relies on testimony of a Jehovah's Witness to tag any and all conversations had with any members as part of their internal confessional process and therefore privileged. This interpretation of the statute would lead to absurdities. I love that. I love that. Here at the bottom of page 12. Interpret, and this is in bold print, interpreting the statutes as the defendant suggests would lead to absurdities. See, and that's like I mentioned before. Watchtower is demanding their rights and, you know, you interpret the law like this. No, you don't get to interpret the statutes and laws the way you see fit. You have to take it as a whole. And then they mention again over on page 13, the statutory interpretation the defendant seeks this court to make would lead to absurdities. Okay, page 14. The purpose of the statute is to protect some of the most vulnerable members of our society, children. Conversations and information about CSA are required to be reported by mandated reporters. If this court were to rule that all information discovered during conversations between the defendant and Mr. Hernandez, Pedraza, and Ms. Hernandez are part of the internal confessional process of the Jehovah's Witnesses without knowing the contents is not only absurd, but would lead to further absurdities. It would open the door to any church or any organization to stretch the limitations placed on Section 8-803, attaching them to some internal confessional process, and therefore preclude any member of the clergy from having to report allegations of CSA. This would undermine the legislator's intent when it amended the Act to include members of the clergy to the list of mandated reporters. Allowing a church to define what are confessions or admissions would allow it to hide all such conversations under an umbrella it itself creates. I love that. And he's absolutely right. If they allow Watchtower and Pinkava and the other elders to do this and get away with this, then that means that every single clergy and church could define, oh, well, this is inadmissible because this is a confession. And then they could hide all such conversations under an umbrella it itself creates. The state asks that this court not interpret the Abused and Neglected Child Act to allow for such absurdities. Both the intent of the legislator and the purpose of the statute would be undermined in doing so. Defendant should be required to prove to this court that the conversations it is asking this court to deem inadmissible are confessions or admissions and made only for spiritual counseling. The state would contend, especially with respect to conversations had with Ms. Hernandez, the defendant will not be able to do so. But, you know, you can see Watchtower is trying to get out of this. And in the very last page, it says, the people pray that this honorable court deny defendant's motion in limine number 3 through 6, and for such other remedies as the court deems just. So, I like this state attorney. He seems to be on the ball here, and I just wish more of these courts, you know, would go after the elders. But the thing is anybody who knows a JW elder, they should be told, they should be warned that they need to check their laws states their state statutes and laws themselves. Don't rely on Watchtower to give you the accurate, up-to-date information. You need to find out if your state is a mandatory reporter. You need to find that out, because these elders, everyone is tired of them getting away with all this. We're tired of Watchtower getting away with this and hiding this under the clergy patent of privilege. You know, I cannot believe that every single current Jehovah's Witness, if they knew all of this was going on, that they would stay with this religion. It's not God's organization. You think God would put up with all of this? He's supposed to have a clean organization. I've been told my entire life, this is Jehovah's clean, morally clean organization. No, it's not. It's not. Our friend Jane Doe, she was just reading an article, and back in, I think it was the 50s, they mentioned in a magazine that there's no wrongdoing in their organization. It's like, oh my God! Watchtower's days of trying to hide this are done. They're done. You cannot hide this anymore. You cannot, put your head in the sand and pretend this will go away. Oh, well, don't go on the internet, it's Satan's and the apostates' lies. You can't do that anymore. Jehovah's Witnesses are doing the research. They are going online. And this case, all the Jehovah's Witnesses in Illinois are hearing about it. So Watchtower, you can't shut us all up. This is going to get out. So thank you so much, everyone, for watching. And you all have a wonderful weekend. Bye.